Give this just 1 second to start. Okay. This should be... Okay, it started. All right, let's go on the record then. The hearing will be in order. We are here this morning for a formal hearing in Wayne County Community College District and Wayne County Community College P and AA AFT Michigan Local 4467. That's Merck case number 20-I-1436-CE, docket number 20-017955-MERC. The time is now 10:18. Let me get the appearances from the parties, and then I'll go over the procedural history of this case and set out a few ground rules for how we're going to proceed today. Appearing on behalf of the charging party,
Mark Cousins.
thank you very much. Appearing on behalf of the respondent. Oh, you're muted, Mr. Ayer. Or I'm not hearing you, at least.
On air.
Thank you very much. I should indicate that the ALJ appearing on behalf of the Michigan Employment Relations Commission, or MERC, this morning is David M. Peltz of the Michigan Office of Administrative Hearings and Rules, or MORE. We are here on a charge that was filed on September 8th of 2020 by the union. There was a motion for summary disposition filed by the employer. That was filed on September 29th of 2020, and the union filed a response to the motion on October 16th of 2020. We're going to discuss the motion and how we're going to proceed on that in just a moment. I did want to note a couple of things first. We have had some off-the-record discussion this morning about how we're going to proceed. Mr. Cousins, you indicated to the rest of us that you believe we can proceed solely on the exhibits, and you do not intend to present any witnesses in this matter. That's correct?
That's correct.
Okay. Mr. Ayer, in light of that, I believe you indicated then that you are good with presenting only exhibits today as well.
That is correct, Your Honor.
Okay. And that it was my thought, if that's the case, that the proper way to sort of present this is, since there is a motion for summary disposition outstanding, is to treat this as oral argument on the motion. And we'll go ahead and talk about what exhibits the parties will be relying on for purposes of that oral argument. However, I understand, Mr. Cousins, that you do wish to file a supplemental brief with respect to the arguments set forth in the motion and response. Is that correct?
That's correct. And an additional event has occurred since the submission of the motion and the response that is reflected in Exhibit 11 that I'll discuss when given an opportunity.
Okay. And Mr. Ayer, are you good with filing supplemental briefs?
Yes, I am, Your Honor. The employer does, potentially have an objection to what the union is trying to raise on the eve of hearing. If this is a new allegation, we believe the union should have amended the charge to provide the employer with notice so we could defend against the allegation.
Well, I don't have any knowledge, obviously, of what we're talking about here in terms of the allegation as of yet. Why don't we do this, Mr. Cousins, when you bring up this either new event or new allegation, at that, I think that's the appropriate time, Mr. Ayer, for you to raise an objection if you have one. Normally, I don't. If we're having oral argument and a motion has been fully briefed and the response has been filed and briefed, I don't typically allow supplemental briefs unless there's some specific need for it. However, I think in this case, it is appropriate, uh, uh, given not only given the circumstances, but I had some additional questions after reading your briefs, where I felt that there was some additional information necessary after reading the brief and response. So we'll go ahead and we'll talk about a timeline for filing those supplemental briefs once we're finished. Okay. Before we get started, then uh, I did have some preliminary instructions for witnesses in terms of in a remote hearing setting. Obviously, that's not necessary, but I do want to stress to everyone who is involved in today's oral argument then that you do your absolute best to avoid speaking over each other. If you want to interject or object at any point, it may be helpful for you to raise your hand first so that I can acknowledge and recognize you for speaking, so that our court reporter can accurately transcribe the proceedings. I'd also ask that all participants keep their devices on mute when they are not speaking. If we need you and you're muted, I will let you know, but this is important to reduce feedback and limit background noise. There's an icon in the lower left of your screen for muting yourself. You can also mute or stop your video if you are not actively participating. That will save you some bandwidth at the very least. I'd also recommend, I know you're all set up here, but if anyone has any a headset with a microphone, to use that. That typically helps, again, with background noise and make sure that we have everyone can hear each other with maximum quality. Now, as I indicated, this hearing is being uploaded to YouTube today, so that it is available to the general public. MERC hearings are typically available and open to the general public. People can walk into our hearing rooms when we are not conducting remote hearings. And I believe it's important that we try to maintain that openness, even though we are doing these hearings over Zoom right now. This is, as best as I can tell, the first time perhaps in more that this is being done. So this is a little bit new. It's a pilot program. There are some, I'll be frank, there are some concerns in some other areas that deal with confidential or highly private information. There's some concern with how that's going to work if we use streaming on a more broad basis. We typically don't have those issues in MERC hearings. And as indicated off the record, I've gone through and redacted personal information from all of the exhibits in the event that there is screen sharing during this hearing. Again, this is part of a pilot program, so there are no formal guidelines. However, my intent is to keep the YouTube recording of this hearing up for 7 days after the hearing, at which point it will be deleted. Now, the recording is not the official record of this proceeding, and therefore it's appropriate and for me to delete it at some point. It's not going to be relied upon, and the party should not rely upon it as an official recording. The official record is the transcript being made today by the court reporter. Any questions, concerns, objections with respect to anything I've said thus far?
Not from the charging party.
None from the employer, Judge.
Okay, thank you very much. And I did send out a link to the YouTube page via the chat prior to the start of the hearing, so that any individuals affiliated with the parties today can go back and view the hearing. The final thing we need to do before we get started is go over the exhibits. The parties both sent by email copies of their proposed exhibits for what, again, was initially to be an evidentiary hearing today. However, since we're doing this now by oral argument, and it's my understanding that the parties have agreed that I can consider all of these exhibits for purposes of the oral argument, I want to go through and identify them, and then I will get your agreement on our admitting these today for purposes of the oral argument. I'm going to identify the exhibits by number consecutively, and also give a brief description. Understand that my description is just for identifying purposes and is not meant to convey my understanding of the substance of the document. It's just so that everyone knows that we are on the same page with respect to these documents. Okay, the first exhibit that I received that I have marked as Respondent 1 is a copy of the collective bargaining agreement that covers the period of 2019 through 2021. Respondent 2 is an email. Now, when there's an email chain, I typically, for identification purposes, will simply refer to the first email at the top of the first page. So I'm going to refer to Respondent 2 as a June 10th, 2020 email from Ms. Barnett Novak to Mr. Sanford, and that includes various attachments. Respondent 3 is a June 10th, 2020 email, again from Ms. Barnett Novak to Mr. Sanford. Respondent 4 is a October 14th, 2020 email from Ms. Barnett Novak to Mr. Sanford and to Mr. Mickles. Respondent 5 is a grievance dated June 29th of 2020. Respondent 6 is an arbitration demand dated September 4th of 2020. Respondent 7 is a request to hold grievance in abeyance dated September 15th of 2020. Moving on to charging parties exhibits. First one will be identified again consecutively, so charging party 8. It's titled at the top, Telework P&AA Positions. Charging party 9 is entitled ULP Proposal. This is from the union to the employer. Charging party 10 is an October 19th, 2020 email from Mr. Ayer to Mr. Cousins. And I'll note that the file that I received that we're relying on, and we've talked about this off the record so everyone understands, the file is entitled Corrected Number 10. Charging party 11 is an October 20th, 2020 email, again from Mr. Ayer to Mr. Cousins, the top email. Those are the exhibits that I have received. It's my understanding that both parties have agreed to the admission of all of those exhibits for purposes of today's argument. Is that correct, Mr. Cousins?
That is correct.
Mr. Ayer?
That is correct.
Okay, I will go ahead then admit exhibits 1 through 11 into evidence. And we will begin with oral argument. Now, one procedural issue, this goes to the semantics of how we're proceeding today, Mr. Cousins. When I asked you off the record how many witnesses you had, and you indicated you're just going to rely on exhibits, and then I indicated that it's more appropriate to do this by oral argument. Therefore, since this is an oral argument on the motion, typically the moving party would go first. Does anyone have any thoughts or concerns about how we present this argument?
Yes, Judge. I anticipated that. I think that the charging party should proceed because the issues that are raised within the respondent's motion are actually the substance of the legal question to be decided by the commission on the matter at hand. The charging party has the burden of proof and the burden of persuasion, but it comes down to two legal questions. In summary, the first is employer refusing to bargain in good faith by inappropriately relying on what the union views as an irrelevant contract section to justify its either reluctance or outright refusal to meet and confer with regard to employee safety. And the second, which is the new event, is the employer refusing to bargain in good faith by declining to meet by Zoom in order to bargain. The union acknowledges that we have the burden of responsibility and burden of proof on both of those arguments. Our contention with regard to the irrelevance of the contract section on which the employer relies goes to the substance of their motion. So I suggest that by the employer going first, it would kind of put the case on its head. You're going to have to reach the question anyhow. And so the union is prepared to proceed on both of the issues that I've just posited and brief them and invite the employer to respond as it deems fit. I don't think it's denying the employer any measure of due process by us going first. I think it just actually makes the record clearer and a little bit easier for you to approach.
Mr. Ayer, do you have any objection to Mr. Cousins going first?
Yes, I do, Your Honor. The employer has an objection to the second allegation. This is a new allegation that just came to light today. The union has alluded to this issue over the past couple of days, but this is something new that was not contained in the original charge. So the employer does have the due process concern. If the employer is forced to go forward with the second allegation, then my statement about not having any witnesses, I will need to call a witness if this issue, this allegation is to be litigated today.
If I can respond, Judge.
But before you do,
Yes.
let the new allegation notwithstanding, or let's put that aside for a moment. In terms of order of argument, besides the issue with the new allegation, do you have any concern, an objection to Mr. Cousins going forwards, going first in the presentation of arguments?
No, I don't, Your Honor.
Okay, all right, thank you. Now, in terms of the new allegation, let's discuss that. Mr. Cousins, you wanted to say something? I'll give you the floor.
The event on which we're relying occurred yesterday, so it couldn't have been part of the initial charge. It is not the union's intention to catch the employer by surprise. There had been some chatter back and forth among the parties about how they were going to meet to bargain. You will note when you have an opportunity to read the exhibits that the employer belatedly offered to meet to discuss the union's concerns. The union then proposed meeting by Zoom. The employer responded. Mr. Ayer's correspondence to me yesterday confirmed that, and that is why we say the event actually occurred yesterday. I can understand the employer's concerns about being able to present a response. As I indicated, it's not our intention to catch them short or to engage in trial by ambush. However, I think that the issue of whether the parties meet by Zoom or not is more of a legal question than a factual one, because the administrative law judge can take judicial notice of the pandemic. And therefore, the legal question, when it's finally framed, will be whether a party may bargain to impasse regarding how the parties are going to bargain in the age of a pandemic. There is commission law, not to anticipate my argument, but there is commission law dating back to the 70s about preconditions to bargaining, but we are in a unique time. So if the employer's not prepared to proceed on that, it's difficult for me to criticize them. But on the other hand, this is such a straightforward question that is really an issue of law that I think they should be prepared to proceed. We would move to orally amend the charge to encompass the issue of meeting by Zoom to conform with the argument that we're going to make.
Okay, let's separate these issues out now first. Let's put aside the issue of the employer's, whether the employer is prepared to go forward with a defense as to the new allegation, and how the employer will do that, from the issue first of whether the employer has any objection to an amendment to the charge to add this allegation. Mr. Eric, can you address that question and that question only first?
Yes, Your Honor. I do believe this is a new allegation. It's a new charge. Like Mr. Cousins indicated, the union did allude to this yesterday. But quite frankly, the employer is prepared to defend this. Quite frankly, I believe the union's raising an allegation that fails to state a claim or a violation under FAIR with this new allegation. And quite frankly, I actually believe the union is actually committing an unfair labor practice by conditioning bargaining that it only take place by Zoom video conference, even during a pandemic. I have not had an opportunity to research Merck Commission law on this issue, but I'm well aware that the National Labor Relations Board has long held that conditioning bargaining, whether it be by telephone conference or video conferencing, is an unfair labor practice under the National Labor Relations Act. So that would be, I believe, persuasive authority to the commission if they have not addressed this issue, which I haven't had time to research. That being said, the employer is prepared to defend this matter. But in light of this new allegation, unless the union is willing to stipulate to a certain fact, I will need a witness to put on the stand to provide some additional details with respect to labor meetings that have been held between the parties and their bargaining teams to date.
Okay, in terms of possible stipulation to avoid that issue, normally if we were all together, and I wish we were in our hearing room in Detroit, I would ask Mr. Cousins and Mr. Ayer to step into one of the caucus rooms and discuss whether a stipulation is possible. Although Zoom has a breakout room function, unfortunately at this time that function is not available on our particular accounts. Hopefully within the next couple months they will activate that, so I cannot do that. So we can do one of two things. I can let you both discuss that either on or off the record with everyone on the line here, or we can pause the hearing and you can have that discussion by telephone and we can come back, whichever you would both prefer.
Here's my suggestion, Judd. If we could all go silent and I could ask Mr. Mickles to give me a call at my office to get some information, then I may be able to call Mr. Ayer at his office because I think I understand what he's asking the union to concede, but I need to know the facts. So with your permission, we would go off the record while I confer with my client and then with Mr. Ayer.
Mr. Ayer, that okay with you?
That's fine, Judge.
Okay. What we'll do is let's take a break then. The YouTube stream, as I understand it, will continue while we do this. I'm going to just stop my audio and video, and it is 10:40 right now. About 10 minutes, is that what you think you need?
Yeah, 2 phone calls.
Okay, let's come back at 10:50, and hopefully we'll be ready to get started with the argument. You'll be able to stipulate to this so we can get going.
Okay, great. Thank you.
Okay, so off the record for right now. Thank you. Mr. Area, have you heard back from Mr. Cousins? Oh, wait, either you're muted or my,
You were correct, Judge. I was muted, but I have not heard back from Mark Cousins.
okay.
Judge Peltz, we have liftoff.
Okay, well, before we're not.
You are muted, sir.
I shouldn't be. Let's see.
I can hear you, Judge.
I can hear you, Judge.
It's just you.
Okay, now I've got sound.
Okay, you can hear me?
I can, thank you.
Before we do anything else, let's go back on the record. Marcy, I don't have your video, but can you indicate whether you're back and ready to go?
I am here and ready.
Okay, let's go back on the record. Mr. Cousins, you had an opportunity to confer with your client.
And with opposing counsel, and it appears the parties are ready to stipulate to some uncontested facts, and the employer has allowed me to recite the stipulation. Mr. Ayer will correct any misstatements. The parties stipulate that during the months of June, July, August, and September, representatives of each side met for a routine labor management meeting. The duration of these meetings ranged from 35 minutes to an hour. For the union, there were typically 2, sometimes 3 people. For the employer, there were typically 2, sometimes 3 people. The parties did not meet in the month of October. The Labor Management Conference is described in the collective bargaining agreement and is a customary activity. By contrast, and these meetings were conducted face-to-face. By contrast, the parties agree that the union negotiating team is typically 6 persons. Management's negotiating team is typically 5 persons, for a total of 11 people who engage each other who have engaged each other in the past in a single room. I think that is the stipulation.
Your Honor, the only thing I would add was the October meeting was canceled by the union because it was not ready to go on that day.
It is correct that there was no meeting in October.
Well, you're saying 2 different things. Mr. Ayer gave a reason for why there was no meeting. Are you stipulating to that?
Respectfully, Judge, I don't think it really matters why. There's an unrelated concern between the parties as to the value of these meetings, and we're really not going to present that to you. I don't think either side is going to present that to you.
Mr. Ayer, are you satisfied, or do you want the stipulation to include the reason?
I do believe the reason should be included, Judge. The reason that was articulated why the union wasn't meeting for the October meeting was that they weren't prepared for the meeting. It wasn't over any sort of safety or health concern that was expressed at that time. So I would like that stipulation.
How about this? Why don't we, are you both willing to stipulate that the meeting didn't occur, but that it had nothing to do with any health or safety concern?
The union did not express health or safety as a reason for canceling that meeting. That is correct.
Mr. Ayer, you're good with that?
Absolutely, Judge. I'm good with that.
Okay. All right. I'll accept that stipulation. I assume that means that neither party needs to put on any witnesses then. Is that right?
We have saved you the pleasure of listening to testimony.
Mr. Ayer?
That's correct, Judge. I do not have to put witnesses on.
Okay. And you have already indicated you have no objection to the amendment itself. I would ask Mr. Cousins that following this hearing, I will accept your amendment, but I would ask that following this hearing, you submit a written amended charge so that there can be no dispute as to what you are alleging. Okay.
File a written amended charge. Yes, I'll do that.
Correct. Okay. And I think you indicated, Mr. Ayer, that other than the amendment issue, you had no problem with Mr. Cousins going first. So I'm going to open the floor then for oral argument. Mr. Cousins, you can go ahead.
Thank you, Judge. This is the rare case in which the parties agree on what has occurred, but have dramatic differences over what it means. The respondent employer has inappropriately refused to bargain with regard to implementing specific safety protocol related to the ongoing pandemic. Further, it has refused to bargain because it contends that the bargaining obligation has been waived by irrelevant provisions of the collective bargaining agreement. And further, having made a limited or restricted offer to meet, the employer has said that it insists on face-to-face meetings, despite the fact that doing so would be unsafe. This case then presents two legal questions. The first is whether the collective bargaining agreement covers the issue of the employer's response to the novel coronavirus, and whether Article 25 sub D, which is an extraordinarily vague and general provision, relieves the employer of its obligation to bargain specifics such as are raised by the union in their proposal to the employer. Specifics needed to ensure that employees are working in a safe and healthy environment. And the second is whether, under the circumstances, the employer commits an unfair labor practice by insisting on meeting face-to-face when doing so jeopardizes or may jeopardize the health of all concerned. Now, to get into specifics of our position, we meet, as you know, amidst the unique health crisis of a century. The fact that this hearing is being conducted virtually by Zoom is exhibit A of the reality of the situation in which we all find ourselves. Starting less than a year ago, every employer in the world was confronted with the problems of keeping its workplace safe. And for the longest time, as you know, employers completely shut down, and that included this employer. Well, they shut down correctly because having employees report to work in person when it was possible for them to work remotely prevented death, not just illness, but death. What happened here is relatively straightforward. As the exhibits show, starting in June, the employer sent a notice to employees that contained some relatively vague explanations of what is to be done to ensure health and safety. Thereafter, the union communicated with a representative of the employer, Mr. Sanford, and began asking questions about what the employer was doing to ensure employee safety, and submitted a formal demand to bargain the safety consequences of reopening the campus. Employees in this bargaining unit do not teach classes. They are administrators who work in offices and are responsible for a myriad of tasks that ensure that the college operates safely and that it fulfills its obligation as an educational institution. They work mostly in close confines. They are not spread out. They don't have classrooms which are large enough to ensure social distancing. And the union was therefore quite legitimately concerned about its staff being required to work cheek by jowl with other employees. The communication between the parties went dark. There was no communication to speak of between June 10th and September 17th. This is not necessarily the fault of either party. It is simply a fact that the parties did not resolve this concern during the summer. Instead, beginning in September, the employer indicated that it was prepared to meet to discuss the union's concerns. However, as is clear from the exhibits, it was the employer's position that meeting to discuss the union's concerns was an act of grace and not an exercise of the employer's duty to bargain, because the employer took the position that Article 25D waived the union's right to demand bargaining, and therefore the employer had no duty to bargain. A series of communications followed the initial emails in September, and the long and the short of it is the employer has offered dates to meet, but has now said in response to union requests that it insists on meeting in person, that it will not meet by Zoom, and that it requires the parties to confront each other face to face. Now, let me discuss the two legal questions which the commission will be asked to consider. The first is whether this issue is covered by the collective bargaining agreement. The administrative law judge may note my frequent and loud criticism of the covered by doctrine, but in a situation like this, it is relatively easy to apply. Article 25D says, and I will quote, "The employer shall make reasonable provisions for the health, safety, and first aid of its employees during hours of employment." That clause has been in this contract for an extended period of time. It was in the prior contract. It was in the contract before anyone had ever heard of COVID-19, before indeed the virus escaped from whatever source it had. And this clause, therefore, could not have contemplated COVID-19 because it didn't exist when the language was written. Moreover, the clause is so general as to be essentially irrelevant. The union has demanded bargaining with regard to the specifics of health and safety, hand washing stations, social distancing, that is work distancing, masking, a variety of things that we now understand are essential to keep employees safe and to avoid the possibility of a work location becoming an opportunity or a place for spreading the virus. This clause does not deal with that. The union initially filed a grievance. However, it became clear that the language in the contract was so general as to be essentially useless, and therefore turned to the obligation to bargain. And it is the union's position that the parties should reach agreement on what, in fact, the employer is going to do. But the employer's response is, well, we'll listen to your concerns. Sorry, that is the unfair labor practice. They can't listen to our concerns. The employer has an obligation to meet and confer in good faith and to try to reach agreement on the specifics of health and safety for the working environment. Now, we're not going to ask the commission to tell the employer specifically what it must do. But what the commission should do is say, stop pretending you don't have an obligation to bargain. Meet and confer in good faith and work to reach an agreement with regard to specifics. Now then, the second question. The second question here is how the parties will engage each other when they do bargain. The fact that we are meeting, in fact, by Zoom is, as I indicated, Exhibit A of why the parties need to meet by Zoom. On 4 occasions, the parties have engaged each other face to face over the union's considerable concern, by the way. But it was a small group. It was relatively straightforward. The meetings were limited in time. The conversation and subjects were limited. They were not engaging in wholesale bargaining. These are routine labor management problem-solving meetings, which I will say the union finds rather unsatisfying, but that's not before the commission. That was not wholesale bargaining. What we're talking about here is wholesale bargaining, in which not less than 11 individuals will have to engage each other to try to reach an agreement on a series of complicated questions. Having 11 people in a room together is inherently unsafe. And I believe that you can take official notice of that while it is theoretically possible to have 11 people in a room in a safe environment, the room has to be the size of Cobo Hall. Putting 11 people in a conference room precludes the possibility of any serious social distancing. They would have to be masked. They would have to have a variety of protections, and it inhibits the free flow of bargaining that usually accompanies face-to-face confrontations. But we are in a situation where the world is on its head. The union is fully and completely prepared to engage the employer at convenient times and places. But the employer's intransigence is itself an unfair labor practice. The commission has indeed, as late as 1980, and I think Kanawha Valley Schools, I have the citation if you wish, noted that neither party may impose preconditions on bargaining. However, the commission decisions say that the reason that a party may not impose these preconditions is that the question of whether they meet on Tuesday or Wednesday is not a mandatory subject for bargaining. This is an issue of safety. And therefore, whether the parties meet by Zoom or face-to-face implicates safety itself. And therefore, it becomes a mandatory subject for bargaining. The employer's intransigence, its outright refusal to even consider a Zoom meeting, therefore is not a restriction or an attempt to impose preconditions on bargaining, but rather is a refusal to bargain safety, which is itself a mandatory subject for bargaining. Now, the employer, therefore, should be directed to stop saying we're going to listen to your concerns and agree to engage the union in good faith with regard to the specifics of employee safety. And the commission should find that this issue is indeed not covered by the collective bargaining agreement. And further, the employer should be directed to participate in bargaining by Zoom at the request of the union, provided that appropriate measures are taken to ensure that the bargaining is competent. We're not asking the commission to say specifically how the Zoom meeting should occur or whether the parties use Zoom or Microsoft Teams or something like that. But the employer should be directed to cease and desist, refusing to meet by virtual means under the circumstances of this pandemic. We can hope that in the long history of the commission, the decision in this case will ultimately be looked at as an arcane outlier dealing with a condition which existed for a year, 18 months, and 5 or 10 or 15 years from now, people will say, well, gee, this is what happened during the pandemic. But we're here now, and therefore, under these circumstances, the commission should act aggressively to have the employer fulfill its statutory obligations. And with that, we rest on the record with the amended charge.
All right, thank you very much. I have some questions for you, but I will save those until after Mr. Ayer has completed his argument. Go ahead.
Good morning, Your Honor. Wayne County Community College District is a large public employer with multiple campuses and facilities. The union in this matter has two components to this charge. The first one is that the employer is committing an unfair labor practice by refusing
Wait, hold on.
to bargain over the health and safety of the union members.
Mr. Ayer,
The union is characterizing
John,
the employer's, yes,
You froze.
Yep.
you froze for a
okay,
moment.
I'm sorry.
If you could just back up one sentence or so, I apologize for that. And that way we can make sure we get your.
Absolutely. The first allegation in this charge, the union is alleging that the employer has committed an unfair labor practice charge by refusing to bargain the health and safety of the charging party's members. Now, the union has characterized the employer's defense as that the union has waived this, and that is not our defense. The employer's defense is that this matter is covered by the collective bargaining agreement that is in effect. So it's a little bit different analysis than a waiver argument. And this argument is this issue has already been bargained. Article 25, the parties have dealt with health and safety. In that provision, the parties have negotiated that the employer will provide reasonable provisions for the health and safety of the union members. The parties also contains a collective bargaining agreement that contains a grievance procedure that culminates in binding arbitration. Now, the union has asserted that this language, because it doesn't expressly mention COVID-19, that it's just too general to apply in this situation. The employer counters that this health and safety provision was purposely negotiated to be general because it deals with all sorts of situations. There are many diseases, hepatitis, there are many safety and health issues that can arise that have to be dealt with in a timely manner. The union has negotiated protection for themselves that the employer must provide reasonable safety and health provisions. If the union feels that the employer is not providing reasonable health and safety provisions, they can file a grievance. And in fact, in this matter, they did. Exhibit 5, the union did file a grievance asserting, a violation of Article 25, Section D. And in this exhibit, the union explicitly states that during the healthcare emergency of COVID-19, the district has failed to provide adequate safety measures to essential staff who are needed on campus. The employer, this is proof that the union even acknowledges that the contract addresses this specific issue, because in fact, they did file a grievance on this matter. What's interesting to the employer is no one is going to deny that COVID-19 is a very unusual circumstance, and it's important for our employees, our visitors, our staff, and for everyone to be safe. But what's interesting to the employer is that there was an active pending grievance on this matter that was in front of an arbitrator that's been selected, and the union requested to put this matter in abeyance. Now I'll speak to the second allegation regarding face-to-face meetings. As was stipulated on the record, the parties have been conducting labor management meetings since June, which occur on a monthly basis, face-to-face. Albeit, as was stipulated, this is not a full complement of what would normally be when the parties are negotiating for a new collective bargaining agreement. But as I indicated, the employer is a very large community college district. They have large facilities. We have lecture rooms. We have large conference rooms that allow for social distancing. So these meetings can be conducted in a safe manner for all participants. Now, the employer's position is that the duty to meet and confer also encompasses face-to-face meetings. The employer's position, quite frankly, is the union is conditioning bargaining on having it conducted by Zoom, which is a condition to bargaining, which we believe would be an unfair labor practice in and of itself. But let me speak to why the employer would like to have these meetings conducted face-to-face. One is to make sure that we're having open and frank discussions. One concern from the employer's perspective is if these meetings were conducted by Zoom, it's very simple for a party to, record the conversations that are taking place. That is one issue. Another issue is typically when you're having face-to-face bargaining, you can also focus on the other members or participants to get the temperature of the room, I might say. You could be presenting proposals where the chief negotiator may not be in agreement, but you can read the facial expressions of the other participants, albeit they'll be wearing masks, but you could read their facial participations, whether they're nodding their head in agreement or disagreement. Another reason for conducting face-to-face meetings is if the parties are able to reach tentative agreements, you can simply have someone sign off on the agreements right away. If you are having to do this by video conference and have to submit a document for signature, sometimes people get cold feet and don't sign the agreement. So there's numerous reasons why face-to-face meetings are very conducive to collective bargaining, and the employer's position that is part of the duty to meet and confer in good faith is to have a face-to-face meeting. It's for these reasons that we believe the charge and the amended charge should be denied in their entirety.
That completes your argument?
Yes, it does.
Mr. Cousins, I saw you raise your hand. If you
No, I was typing, Judge.
Okay.
And press the enter key with emphasis.
Okay. I have some questions for both of you, as I typically do when we have argument. First, I want to get some clarity on 2 points. I think you addressed this for the most part, Mr. Cousins, but I want to make sure that the record is very clear on this. If I deny the motion for summary disposition, and in this case, it's quite apparent that I have 2 options: grant the motion and dismiss the charge, or rule in favor of the non-moving party, as I am authorized to do. That I want to make sure that if it is the latter, that I know specifically the relief sought from the charging party. So, Mr. Cousins, let's start there. If you could, with some certainty, explain what it is that you would like the commission to order in this matter, should it rule in your favor.
I'm trying to articulate this properly. I think it is a direction to the employer to cease and desist, refusing to meet and confer in good faith with regard to employee safety by asserting that the duty to bargain is covered or is waived by or superseded by Article 25D of the collective bargaining agreement. I think that is the essence of what we're saying. To put it in the vernacular, tell them that they have an obligation to bargain the merits of health and safety, the specifics rather of health and safety, and they cannot rely on Article 25D of the contract as an excuse for refusing to confront the union on the specifics. We are, as much as it would be fun to do so, we are not asking the commission to direct the employer what it should agree to. That is, hand washing stations, things of that nature. We are asking the commission to say, stop saying you don't have to bargain and meet and confer in good faith.
And as to the second allegation?
As to the second allegation, tell the employer that it cannot refuse to meet by Zoom in the absence of any viable reason to object. So, I mean, suppose, for example, that the employee, not in this case, but the employer would have to purchase expensive technology in order to accomplish that result. Well, that might be a reason not to, but that's not the case here. And with respect to my friend, Mr. Ayers' arguments, their arguments are essentially specious. Stop refusing to meet virtually so long as it is appropriate to do so and the bargaining process is not unreasonably inhibited by virtual meetings.
Okay. On a potentially related issue, and I don't want to introduce something that is not part of the charge, but I think I need to get your positions, both of your positions on this issue, so that the commission has a full understanding of what may be occurring here. The question of impact. If the commission were to determine that, in fact, this matter is covered by the contract and grant the employer's motion, that solves one problem that the parties may have. It's conceivable that you might be right back here again, though, if an impact issue arises thereafter. And as you know, it can be difficult sometimes to, those issues can be very closely intertwined. So let me put this question to you, Mr. Ayer. I understand your argument again that the contract covers this issue, that the parties have bargained about health and safety. Does the college have a position in terms of its duty to bargain the impact of its decisions?
We do, Your Honor. The employer's position is, since the matter is covered by the parties' collective bargaining agreement, the employer has no duty to bargain the decision or the impact of that decision. And I have a citation. This is the matter of the city of Royal Oak, 23 E107.
Look,
It's a
Mr.
2010 Merck decision.
Can you back up a little bit when you lean over, you go off mic and we couldn't hear you.
Sure. The citation is 23 MPER P107. It is a December 22nd, 2010 Merck decision.
What is the first digit, Sean?
23.
23 M per, I'm sorry, of the last cluster, 2307?
P107.
P107?
That's correct.
That's the way.
Huh. I didn't know M per had those, but okay.
Typically, it's if you just take out the P, it will be page 107 of the.
That's what I thought.
So, okay. Do you want to respond at all? I directed that question to Mr. Ayer. Mr. Cousins, do you want to respond over impact? An impact?
The union's demand to bargain encompassed both the impact of the reopening decision and the safety issue itself. The union doesn't see them as separate issues. We see them as the same question. Specifically, under what circumstances will employees be required to work? Whether one views that as the impact of a decision to reopen or a decision with regard to safety, I think it's two sides of the same coin. In answering your prior question, were you to dismiss the case on the grounds that the contract covers this, we'd be back to arbitration, where regrettably an arbitrator would be put to the task of deciding minutia of what is safety and what is reasonable safety and what is not. The parties are vastly better off resolving that themselves. But I frankly do not see the difference between bargaining the impact and bargaining the substance of safety. I think it is one and the same thing.
Let's go back to what you just said, though. This is another area I wanted to hit with respect to reasonableness. Now, I'm not going to make any finding right now without further consideration as to this particular contract clause and whether it's sufficient to constitute constitute a sort of covered to support a covered by analysis. Mr. Cousins, you indicated that it's unfortunate if an arbitrator has to decide the reasonableness issue here and the minutia of what the appropriate safety and health measures would be. However, you would acknowledge that that's not an unusual position for an arbitrator to be in, and that's a typical remedy. The union, in fact, has a remedy here. There are numerous Merck cases in which the commission has held that a matter is covered by the contract, specifically when there is a contract provision talking about reasonableness. The commission has said, well, reasonableness and what is reasonable and what is not reasonable is a question for the arbitrator. Again, I'm not saying that this contract language is arguably, at least, is a little different than some of the others, but there is a remedy here for the union, is there not? Should I grant, or should the commission grant the motion?
Well, there's an alternative. I don't want to say it's a remedy. The alternative is to try to fit a square peg in a round hole. We're saying to an arbitrator, you have to decide what is reasonable safety measures. Putting an arbitrator who is trained on contract law and labor relations law into the shoes of Anthony Fauci. Is it reasonable for the employer to have a to have a hand washing stand every 6 feet as opposed to every 8 feet? It means that the arbitration will be days in duration as the parties present a plethora of expert witnesses who will then try to educate the arbitrator on what is reasonable under the circumstances. That is what the bargaining process is for. The parties themselves are vastly better able to decide what is reasonable under the circumstances than asking a third party to impose it, because the third party can only tell the parties what they have agreed to, not what they should agree to. And that is what the problem is here. The reason that this clause does not cover this dispute is that it is so vague and general as to essentially be worthless. It is a general promise to have a safe workplace, which is redundant to the employer's inherent obligation anyhow. It is not a specific agreement as to what the employer is going to be required to do under in response to the most unique health challenge in the history of the world. Greater than the plague, greater than the flu of 1918. 200 and what is it now? Almost 50,000 people dead. So that is why I cannot imagine that this clause has any relevance here at all.
Mr. Ayer, do you want to respond? The question was posed to Mr. Cousins. If you have anything you'd like to add on this point, I'll give you that opportunity before I move on.
Absolutely, Judge. The parties carefully crafted this collective bargaining agreement and have agreed that the employer has to provide reasonable provisions for health and safety. Now, what the union's asking you to do now is to change the benefit of the bargain. They're saying the language is not specific enough. Now, let's accept that. If the parties were to have to expressly list every infectious disease or every potential safety or health violation, this contract would be thousands and thousands of pages long. The language was written general on purpose. This is so the employer can act in an expedient manner to address safety and health. Now, the union has negotiated safeguards. The employer has to provide reasonable provisions. So the union does have remedies here. They can file a grievance and go to arbitration. They could file a complaint with OSHA if the employer is not following health laws, regulations, or guidelines. That has not happened here. Again, I want to reiterate, the union did file a grievance on this matter, and neither side is going to dispute that the pandemic and COVID-19 and health and safety are not important, but the union had a matter proceeding in grievance arbitration and put it in abeyance. And it's inexplicable why, if they feel that the employer is not providing adequate safety and health provisions for its members. So the parties should be able to rely upon the agreed upon bargain in their contract. So
let me ask you, Mr. Ayer, a couple of the points you just raised. First of all, I assume you're not going to dispute that you've indicated that the parties negotiated this provision and made it general on purpose, et cetera, et cetera. You don't dispute that COVID and the current health crisis is unprecedented and represents a unique situation, certainly in American history.
No, I would dispute that. Pandemics occur from time to time. COVID-19 is called COVID-19 because there was a COVID-18, there was a COVID-17, there was a COVID-16. Again, this language was written very general.
Yeah, I don't want to argue that. The 19 signifies the year.
Yeah, there was no COVID-18. This is, COVID-19 refers to the year in which
There
coronavirus
have
was discovered.
the COVID virus is not unique to COVID-19. There are previous variations of the COVID virus. And let's talk about, there was a pandemic, the Spanish flu in 1918. Pandemics have been around. There are other diseases. The parties purposely did not specify each and every potential safety and health issue that could arise in the contract on purpose. So the contract was generally written.
Okay, let me ask you about that provision again, though.
Sure.
Provision, it reads, quote, "The employer shall make reasonable provisions for the health, safety, and first aid of its employees during hours of employment." Couple things.
Yep.
That provision reads differently than some of the other provisions that where Merck has found a dispute to be covered by a contract where there's a reasonableness language in it. The clause does not say the employer shall determine, for example, what health and safety provisions are reasonable and provide for the unions a remedy for the union, whether it be to request a special conference. We've seen in some cases to file a grievance, what have you. Rather, it says the employer shall make reasonable provisions. It seems to me that this language is a bit more general. Do you want to, I guess, do you want to address that? And I'm concerned that language, there's an interpretation here that certainly doesn't mean what you say. What you assert that it means, I should say. That question's to Mr. Ayer.
Yes, again, Your Honor, the Merck standard is whether the collective bargaining agreement can be reasonably relied upon with respect to addressing the issue in dispute. And we're asserting that Article 25, Section D can be reasonably relied upon. The language says that it's not permissive. It says the employer shall make reasonable provisions for the health and safety and first aid of its employees. That's clear-cut language. It's mandatory language. It was agreed upon by the parties. We also have an employer rights clause under Article 5, which is very expansive and allows for the employer to adopt operational procedures, revise and enforce personnel policies, operational procedures, that's Article 5, paragraph J. And the parties also negotiated a waiver clause in their contract under Article 31.
Has that completed your answer? Or you
Yes.
looking for? Okay.
Yes.
All right. Let me get clarification from you, Mr. Ayer, on another point. Again, I understand your claim that this matter is covered by the contract, which means that in your words or your client's interpretation that the parties have negotiated over this subject and therefore there is no duty to bargain over it, correct?
That's correct.
Let me find out if there's any dispute about this, though. Let's assume hypothetically for a moment that this provision, Article 25, what was it, B, I think? I don't have it in front of me anymore, but that the health and safety provision wasn't in the contract. Is there any dispute from the employer that employee health and safety, particularly here where we have an ongoing pandemic, is otherwise a mandatory subject of bargaining?
No, we would agree that generally health and safety subjects are mandatory subjects of bargaining. We would agree with that. But again, like we've indicated, this has already been bargained.
Okay, so you do
Yep.
agree. One other point I want to just address with you, and then I have a point to question for clarification from both parties. You've made the argument that the fact that there's a grievance that has been filed is proof that the contract is an admission by the union. I think those were your words, that this matter is covered by the contract and therefore the charge should be dismissed. You would agree that the commission has acknowledged in numerous cases that a matter can be both appropriate subject for grievance and an appropriate subject for a ULP, and that there can be both contract and para issues raised by a dispute, and that the mere filing of a grievance does not leave the commission without jurisdiction to address a particular charge.
Yes, but let me put a caveat to that, Judge. In this case, it's ironic that the union is asserting that the collective bargaining agreement does not cover this dispute in this Merck proceeding before you. Yet in the grievance, and why I'm stating that it's an admission, the union is asserting that due to the healthcare emergency of COVID-19, that the public employer is breaching its collective bargaining agreement and citing the very article and section that the employer is relying upon, stating that it's covered by the contract. So that is why we believe it's an admission.
Okay. Anything you want to add or touch upon, Mr. Cousins?
I'm sorry, Judge, that was to me?
Well, I haven't, I've been questioning Mr. Ayer on a few topics. I didn't know if you had anything that you wanted to touch upon based on my questioning of.
Well, I would note that my friend Mr. Ayer seems to be unique in his belief that this pandemic is just something ordinary. I was a little bemused to hear him suggest that. No one believes that. The submission of a grievance as an initial response to the employer's intransigence is not an admission. It's clear it's not. At most, it's alternate pleading and not a concession by the union that the contract covers this. If the contract covers this, and if the unfair labor practice is misplaced, the commission will tell us that, although we don't agree with it. Then we have the grievance option, to be sure, but we do not believe that the contract covers this, which is why the grievance was put into abeyance, because we think that this is best bargained and it should be bargained by the parties.
Right. I put Mr. Ayer on the spot with respect to my question about whether this is a unique situation. Let me put you on the spot for a moment, Mr. Cousins. You made the argument, which is really a factual argument, and we're here. I don't think this is in any of the exhibits, but you asserted that the fact that we're all here today by Zoom is proof that the parties can and should, or cannot and should not be bargaining in person. However, you would agree, and I guess I'm taking judicial notice of this if I have to. There are courts within the state of Michigan now that are open and proceeding in person, are there not?
The courts that are open in the state are restricting their in-person trials to criminal cases because the concern relates to a constitutional right to a speedy trial. The administrative agencies, and to my understanding, all courts with respect to civil matters are conducting proceedings by virtual methods. I have had a couple of federal court proceedings by Zoom, one in which the magistrate kept losing her connection to the internet. But that it is not my understanding that courts are universally open for proceedings other than criminal matters, and I think it is a relative handful. I just received a decision from the Michigan Court of Appeals on a complicated question of government immunity, which was issued and published, but presented without oral argument. Typically, the Court of Appeals waives or disregards oral argument when it considers a matter to be unsubstantive. An argument wouldn't be helpful. The Court of Appeals appears to be doing this routinely. I am not aware that the Supreme Court is conducting in-person arguments. My understanding is that the Supreme Court is conducting either no arguments or virtual arguments. And lastly, my understanding is that the United States Supreme Court is considering virtual arguments. So it is true that there are a few courts in Michigan and elsewhere that are conducting criminal cases to ensure that the defendant receives a speedy trial, but it is not universal.
I'm not going to make a judicial notice of this. I will note that is not entirely correct. There are some courts in civil proceedings that I know some attorneys who have mentioned they've had to go in and we're not happy about that. So, but if there's a dispute of fact about that, I'm going to leave that. We're not having a hearing in this matter, and unless that becomes relevant, and I have to reach back to the parties to reopen the record, we'll just leave that. That was an aside that I will not be relying upon. However, I do on that issue. I do want to. There were some assertions within your arguments that, and again, I received your exhibits, some of them yesterday. I've not gone through all of your exhibits closely, but I'm assuming that there's nothing in the exhibits which would support, first, Mr. Cousins, your assertion that members of this bargaining unit work in close confines and the like. That similarly, there were factual assertions from Mr. Ayer about what makes for effective negotiations and what may hamper effective negotiations. I believe that none of those things are in the record in this matter, correct?
That's true. I think the parties can agree that for the most part, the PNAA unit members work in offices, and the offices vary from place to place. We're not going to burden the record with an examination of every place that they work and how close they work next to each other, but they are office workers. They do not stand in front of an audience, which faculty members do. So they are going to be in closer proximity than faculty to students. With regard to the employer's view of what makes for good and effective collective bargaining, I cede to them their opinion. They're certainly entitled to that perspective. That doesn't mean that it is binding on the union.
Okay. Mr. Ayer, do you want to touch upon that, particularly, I guess, the issue of what members of this bargaining, the conditions under which members of this bargaining unit work? Do you take issue with Mr. Cousins' characterization of these individuals working in offices of various sizes?
No, the employer does not take issue with that. But again, I would point out that the parties have been, the employees have been working on site, a good majority of them. But we've also, again, we've been having labor relations meetings that have been conducted face to face. This issue about meeting by video conference is something that just came about recently, right before this hearing. So the timing is somewhat suspect with respect to that issue. I would also like to touch about comparing collective bargaining with, trial court hearings and court hearings. The employer is aware, and I am aware, that MERC mediators are conducting in-person sessions between parties for collective bargaining and have been doing so over the last few months. So I don't think it's appropriate to compare the collective bargaining session to a public court hearing. Collective bargaining is typically private between the parties with a predetermined number of individuals, and you can plan accordingly for the size of the conference room to allocate for social distancing. A public hearing would be much different because you can't contemplate the number of individuals that may participate in that matter. So there are some differences between collective bargaining and trial court hearings.
Before I conclude, is there any response from you, Mr. Cousins, or anything else you'd like to raise right now?
Just the observation that in trial court hearings, there are rules. I'm not sure that there are rules in collective bargaining. The employer's perspective on what makes for good bargaining is their perspective. I'm not going to argue with them about it. The long and the short of it is that Zoom, as we have seen, as we are seeing, is an effective method of communication, and there is no particular reason why it should be rejected out of hand.
Anything else from you, Mr. Ayer, before we conclude?
None from the employer.
Okay. All right. Those are the questions I have for you all. I know that, again, there's a request from, at least from the charging party, and to file a supplemental brief. And obviously, Mr. Ayer, you'll sure you want to file a response or a supplemental. So the only question then is in terms of timing. Typically what we do in a hearing situation is we have briefs come in 30 days after the date that the transcript is sent out. Actually, let me go back and talk about timing as well. I know that this is an ongoing situation. The grievance is on hold, as I've heard from both of you. But you both know, just by the nature of the way Merck proceedings work, that it's not a process which is set up for an immediate decision. The commission there's no procedure for any emergency orders, even though this is, I understand, a situation and probably of great concern for both parties. Of course, regardless of my decision, the parties have the right to file exceptions, and there are time parameters set forth for the exceptions process. So it's not an immediate impact type situation. So while I will certainly and always do take into consideration any requests from the parties to expedite a decision and recommended order, just want to make sure that everyone is aware that this is not a situation where there'll be finality within a week or two. That's just not the way the rules in the statute are set up. And I know you both understand that.
I will say for the record that the union is prepared to engage the employer on these issues. The best case scenario is that this becomes moot because the parties reach some kind of agreement. So I will note for the record that the pendency of this charge does not mean that the union is stopping bargaining or stopping its interest in bargaining. We are happy to meet with the employer, provided we can agree on a method to see if we can't get this resolved.
Okay. Mr. Ayer, do you have anything you want to add on that point?
No, I do not, Your Honor.
Okay. I do want to give you both to have an opportunity to have the transcript in front of you when you craft your supplemental pleadings. But rather than 30 days, I think I'd like to start with a supplemental briefing deadline of 14 days from the date that the transcript is sent out to the parties. So what will happen is, and I'm not sure with our court reporter today, Ms. Klingshirn, if we've worked together before, but typically what happens is at the time the court reporter mails out a copy of the transcript to my office and to whoever else orders it. At that same time, the court reporter will also send a letter to the parties, regardless of whether you've ordered it, with specifying the due date, and the due date will be 14 days from the date that the transcript goes out. Now, if either party needs an extension of that 14-day period, and we do have the holidays coming up, and I'm not sure where that's all going to fall, I'd ask that you, Mr. Ayer, Mr. Cousins, you contact each other first and attempt to get agreement on a new date, and then just notify me. If there's a dispute, then I'll resolve it.
If we could ask the reporter estimated date of delivery, I won't hold her to it, but just to give us some idea of when a record will be available.
One moment. Looks like November 5th would be the latest.
November 5th.
Correct.
Okay, so that would make the briefs due 7/14. I got that right. 7/14, the 19th, give or take a day.
That's right. Right before Thanksgiving, I think.
Yeah, that's satisfactory.
Mr. Ayer, are you okay with that as a starting point?
That is fine.
Okay. All right. Thank you very much. And again,
And just to clarify, Judge, these are principal briefs, no replies, and simultaneous filing.
it's not my intention to accept replies since this has already been briefed once before. If either party has reason to believe that a reply brief is necessary, bring that issue to my attention and we can have a discussion either via email or by conference call and attempt to get that issue resolved. I'm not at possibility, but it's not something that I think will be necessary in this matter.
And simultaneous filing
Simultaneous filing, correct.
by email to you,
To my secretary, I think
to
you have
Ms.
her-
Wills. Yes,
Yes,
got it. Thank you.
give out the email on this because we are on YouTube right now. Okay, anything else that anyone wants to put on the record?
Nothing from the charging part.
Mr. Ayer?
Nothing from the employer.
Okay, thank you. I would ask both Mr. Cousins and Mr. Ayer to stay on the call. And once we are done with, I know that you may want to make arrangements to order a copy of the transcript, and we'll do that in just a moment. After that, I'd ask that everyone but counsel leave the call so I could discuss one issue off the record with both of you. I'm going to close the hearing now in terms of the transcript, ask the court reporter stay on so we can deal with the ordering process. I'm also going to end the YouTube stream now because there will be some information passed along in terms of email addresses and the like. So I'm going to, we'll go